In this lesson, we look at privacy and how to ensure it for ethical and regulatory reasons. The first element of the CIA triad deals with privacy. Maintaining information confidentiality helps ensure privacy for sensitive information. Before discussing privacy, we need to understand what we're trying to protect. PII, or personally identifiable information, is any information that by itself or together with other information can identify an individual and potentially result in identity theft. PII that by itself is enough for identification includes name, address, telephone number, and other data items unique to an individual. Other information, such as date of birth and place of birth, can be used together or with other information to arrive at or confirm a person's identity. Electronic protected health information, or just protected health information, is any information that can identify a patient and associated information about health conditions and health treatments. Many international laws and agreements deal with information privacy. This is some of them. Each organization must understand the legal environments in which it collects, stores, and processes personal, financial, and health information. This list contains several U.S. laws, but it does not include the privacy laws that each state might have in place. We'll now take a look at 5 of the national laws and regulations you are most likely to encounter. The GDPR, or General Data Protection Regulation, was effective as of May 2018. Passed and enacted by the EU, it is a single set of rules to govern the collection, use, and destruction of EU citizen PII. The GDPR applies to any organization anywhere in the world that collects, processes, or stores EU citizen PII. The regulation limits the collection of individual information to that absolutely required for product or service delivery. When the information is no longer needed, it must be securely destroyed. In addition, collected data must be easily transferable from one service to another. Sanctions for noncompliance range from 2% to 4% of an organization's annual revenue. The EU-US Privacy Shield is an agreement between the EU and the United States that enables the safe and compliant transfer of EU citizen PII to U.S. commercial organizations. In order to make the Privacy Shield list of compliant organizations, a business must attest and document its GDPR compliance. The APEC CBPR is a privacy agreement entered into by 5 countries, including the United States, Mexico, Japan, Canada, and South Korea. The APEC CBPR requires that businesses adopt APEC security policies. These policies are currently different from the EU GDPR, but the APEC is considering integrating the GDPR. Accountability agents assess business compliance with the privacy requirements. The U.S. HIPAA, Health Information Portability and Accountability Act, consists of a privacy and a security rule. The privacy rule protects PHI in general and specifies how and when an entity that handles PHI can share it and how. It also covers how to handle PHI in paper-based documents. The security rule largely uses popular security frameworks to specify how to protect the confidentiality, integrity, and availability of ePHI. The Gramm-Leach-Bliley Act, or GLBA, regulates how financial entities have to protect customer PII and associated financial information. Nations implement import and export restrictions to govern and restrict sharing of new and defense technologies, as well as strong protection of intellectual property. One reason for these regulations is the prevention of sharing information that might adversely affect national security. The U.S. State Department used the Arms Export Control Act, the AECA, to develop the International Traffic in Arms Regulation, or ITAR. The main purpose of the ITAR is to control sharing of technology listed in the United States munitions list. These U.S. regulations require an organization to get permission from the U.S. government before sharing restricted technologies. The Wassenaar Arrangement is an international regulatory framework that defines how weapons are exchanged between the arrangement's 42 signatories. In addition to weapons, the arrangement includes the sharing of technologies. Protection of the movement of data is a significant policy concern. Data today creates and increases revenue and provides competitive advantage. Some nations require that collected data continue to reside within their borders. This started with Russia, but the trend continues and is growing. Two main reasons for this are ensuring data security and maintaining a government's legal rights to access the data. According to the CISSP-CBK, more than 34 countries enforce data localization at some level. That's it for this lesson. If you have questions, please ask. And until next time, be careful what you click.